want to update the committee on stuff that I've been involved in on S-230, which has been a constant weird process. Earlier in the day, I had been reacting to language that I saw from the Senate that I was told was the language that they had passed. And it then came to my attention that I was reacting to last night's language. And I looked at today's language, and I sat here with Aaron. I think Mike was here. You were here for, Mary, you were here for a little bit. And I pushed Aaron pretty hard. And his explanation to me is that when we passed the bill over, we did not specifically require the Public Service Board to notify the applicant that their CPG may be contingent upon future sound standards. So Kamash was extremely concerned about that, and so he wanted to make it eminently clear that the Public Service Board would now be required to alert the applicant. In real life, they would be alerted anyway. If that in fact is what it does, and I've asked other lawyers to look at it, because what you don't want to do is create any air of uncertainty and create lawsuits if they're not necessary. So that got me thinking, and we know that the date of April 15th that we put in there, retroactivity, has some potential legal implications, and we never asked the Attorney General about it. Nobody did. I spoke to them today, and I shared with them over the phone the language and some of the concerns that I've heard that may raise. And what I got back from them was just hearing what you described, that's in the language. We would probably have some concerns that may cause. We don't want to do anything that could cause the state some pretty expensive lawsuits if we're creating legislation that would be easily litigated. So I have emailed him the language, and I expect, I'm hopeful to get a reply early in the morning. And if they give a thumbs up, no issue, and I either don't hear back or hear back that the additional sentence that was added is benign and it's okay, we would be able to go good to go. I don't know that we will be able to do that in a timely, in a fashion that allows us to just concur at that moment. Okay. If we go to conference, we would have to close out the conference. And if it's as easy as what I just described, we should be able to close out the conference in about 5.5 seconds. We would have to close it out tomorrow morning for it to get across the finish line. So that's where we stand.
Okay, so in the committee conference, if the Attorney General finds the 15th as the problem, we would, what, in the committee conference, change that date to something fitting?
We would, if folks wanted a bill, you would strike the April 15th.
And what what would the date be? We would not have a date at all?
You would just have the date that the rules would have to be set by, July 1st. In the Senate bill, they've changed our September date back to July 1st of 2017.
Okay, so what would happen to people filing for permits now? Would they move forward, or would they have to wait for
I think effectively it would be the same as if the bill was in effect. So it's case,
What does it mean?
it's still case by case basis. So look, let's be honest, if we pass a bill, okay, that requires the rules to be set by July 1st, 2017, and there's a big project that applies, you think that project is going to, you think the board is going to set a sound standard before they issue the rules for that? I don't think so, okay? But it would still allow for, which is what our language in the bill that we passed allowed for, reasonable smaller projects. If there were no issues, I would imagine that the board would proceed on a case-by-case basis that would set the standard for that project and that project only.
Okay, so in the instances of, like,
I don't-
Representative Gamache is concerned about Swanton, would Swanton be too large a project to, you would think that project would wait?
Oh,
If there are no dates in there, except for the July 1 date,
yes,
and if a developer applied
right,
for a project,
right.
there's no reason for a holdup. And I don't think,
That's true.
okay, so my understanding of the way in which law works generally, you make an application, if there's not a standard in place at the time that you make an application, whatever's there is what you have to, what qualifies you.
Well, there is nothing there.
Exactly. Would be
No,
just
no,
like not having the bill.
no, it would be exactly what you would have today. The board would have to set.
Yes,
No,
now we know how well that has worked.
Well, but what I'm suggesting to you is, in reality, and I know some people hate them and everything, but they're really not that stupid.
Yes, they are.
That if there is a piece of legislation that is requiring them to go through a rulemaking process
Yes.
for projects of the future, okay?
Right.
I cannot imagine that they would jump ahead of their own process because they're so excited about all of this stuff that Swanton would come rushing in with a green light, and that the board would stop everything they're doing and establish standards for them so that they could beat the July 1st
No,
deadline.
of course they wouldn't, but the point is they wouldn't be subject to those standards if the application is filed before the standards date.
But if they don't have a CPG issued with standards in it, they don't build anything. They have to wait until they are issued a CPG
Yes,
with
they have
the
to wait for
standards
CPG.
that the board sets.
But though they could get a CPG in short time before the standards could get set.
The board would have to set the standards.
No, I'm saying that if there's no standards in effect,
Yes,
and July 1 is the date by which the standards have to be set, if a developer applies for a project
yeah,
prior to July 1,
yes.
whatever is in effect in terms of how it works, whatever the procedures are, whatever they normally do, including now, is what they would be subject to. They wouldn't be subject to standards effective after
The
their
board-
application date.
But the board has, for every project they've done, they've set the standard.
And they've
for
been
those
really
projects.
bad.
Yeah, and
They've
that's,
set they've
Yes.
set the standard,
and those
okay?
standards haven't worked out well
Those
to a lot of people.
Bingo!
So they're so what I'm saying is, until July 1 of 2017, there's nothing in effect. There's no
And there's
there's
nothing,
no protection for anybody
And
in
there's-
any town.
and there is nothing that would stop the Public Service Board from saying, we are not going to issue the CPG until we finish our
Okay.
rulemaking process
not
to
how they
establish the sound standards going forward.
And I
And
have
with
to-
everything that is happening in the state and all the publicity and all you folks gathered around here, so you've been camped out here since January, I cannot imagine that the Public Service Board would flip their two middle fingers because they love to piss everybody off, and do that when they're required to go through an intensive, comprehensive, and public rulemaking process
You're wrong.
if this bill passes.
You have far more faith in the system
Well, if
as
I'm
it
wrong,
stands
I'll take you
now
all
than I
to
do.
dinner, okay?
It's a deal.
No,
Okay.
I want more
So,
of that.
Tony,
Yeah.
to get us back on track a little bit. So what we're doing is, we're gonna wait for some opinion from the AG's office, and we're anticipating that by morning, at which time we would convene here as a committee. So should we be here tomorrow morning, like at 9 o'clock? 8:30?
Well, we're gonna be on the floor at 9:30, so.
Well, what I'm thinking is to get something in place so that we don't make a misstep.
Well, if we don't hear anything, then we have to choose our path of whether we concur or whether we ask for comment.
So if the AG tells us that the April 15th date can stay, then essentially
We concur.
we concur. If not,
Well, we got problems.
but there isn't a good alternative.
Put a moratorium.
Other than to yank the April 15th date out and leave the rest of the bill intact.
Yeah, that's-
Right, but I mean,
Put a
Okay,
moratorium.
Pull the
so,
rug out
so,
from
all right, so
everybody.
if you want to
But
kill the bill,
alternative to that?
then you flush all the flush all the town planning pieces down the toilet, and you flush the required rulemaking by the board to set standards, and you have what you have today. And those that like it are happy, and those that don't like it are unhappy.
We have another lawyer in the room. Can we get a reading from our
Sure.
legislative, what
Yeah.
the impact of April 15th then, and why the possibility of lawsuit?
Can you repeat the question? Aaron, at the legislative council.
Yes, there's a question about whether the April 15th date could expose the Public Service Board. I believe lawsuits by people that challenge that.
On what basis would they challenge it? I mean, constitutionality?
I called Bill Griffin, and I described what's in the bill with the retroactive date. And his reaction to me, as you could well imagine, was from the 30,000-foot level, that would cause him concern, but he wanted to see the language and everything. So I emailed him the language, and he's supposed to get back to us with his opinion on it tomorrow morning.
So the language in the bill differs from the vested rights doctrine under Vermont law, which is that rights vest in the rules in effect on the day of the application. However, that doctrine is not a constitutional doctrine. That doctrine is based on statute and common law, and it is the opinion of my office that the legislature may vary from that doctrine. That said, there are constitutional issues with being retroactive. Our basic view of this proposal from this committee was and is that it is unlikely to be struck down as unconstitutional, but every constitutional decision is a fact-specific determination. The reason that it is unlikely is that you are dealing with projects for which permits have not been granted, investments have not been made in construction, and therefore it is likely to be difficult for a developer to maintain and succeed in a constitutional lawsuit. That's our view. The Attorney General may have a different view. A third lawyer may have yet a different view. None of us can guarantee what the outcome will be.
An alternative to striking that would be to say that the rules apply to all applications filed on or after passage of this law.
What?
Did we set a date for passage?
The section
Well, it's
would be
gonna have to be
effective
by
on passage.
6th or 7th.
I'm sorry?
That does throw it into conference committee,
If the conference committee could agree on that, then concur.
Yeah.
I'm sorry, Aaron, you said effective
In the
upon
bill,
passage.
it's effective on passage.
So we could do that, that's the fallback position.
These are all the options.
I like that.
So if the AG says April 15th is a problem, we can switch it to on passage.
If we,
That's one of the
if
options.
this committee of conference agrees to
Committee
it.
of conference option.
The passage is not when the committees agree, it's when the governor signs it.
Right, but we could agree that that's the replacement for the April 15th.
There are other options. You could direct the board to do emergency rules that do a standard that's in place for a period while they do the permanent rulemaking.
That would be even more of a change.
Yeah, it's more complex.
Is it not?
I like Mike's.
On passage, is there a normal time?
On
I don't
passage
know,
still
but
means that the rules are applying to something that might have been filed before the rules were in effect. I'm not sure, if the attorney, so again, we think the legislation is likely to pass muster. We don't know for sure. If the Attorney General disagrees, it's hard for me to imagine that making it effective on passage is going to make a significant difference, but you might want to ask Mr. Griffin that question tomorrow.
Look, hopefully we hear back from the Attorney General that he agrees with our legislative council.
So I'm still a little bit murky on it. The concern is a possible lawsuit.
Yeah.
And do we know if there are any projects that have been filed already? So so if there have been no projects filed for yet, how would we end up with a lawsuit?
Because if you had the April 15th date in and somebody applied tomorrow, you could have a lawsuit.
Santos, who does?
What?
So why would it, okay, I got what you said. Why would it be complicated to change the April 15th date to on passage? I don't understand the complication part of it.
That's not complicated.
That's not complicated.
What did I hear that was complicated? Am I confused? I'm confusing two
Asking
different
for
things.
temporary
Having
rulemaking.
for emergency-
Oh, rulemaking, okay.
having them do emergency rules. I'm not sure that's actually complicated to write a two-sentence thing that directs them to do emergency rules by a certain date. But I think the issue is more the time frame.
Right, so,
I would expect that's
So
what
there-
people meant by complicated. I don't know. I
so
would
there
say it
wouldn't
was
be an issue
complicated.
then? If the AG comes back and says, this is not passing muster, could we then change it from April 15th to on passage
We could propose that, yeah.
to the committee conference? Does that make sense?
Well, may I suggest then, we're kind of in limbo right now,
We are.
that we kind of reconvene at 9 o'clock tomorrow morning and see where we are.
Okay. Makes sense.
Is everybody comfortable with that?
Yeah.
Yeah.
How much choice?
I'll be-
Well, I mean, we're not gonna solve it now.
Bob and I will be.
You can wait here if you want. Yeah, right.
What's that?
The AG's office was gonna get us a response by.
If I don't hear from them by 9 o'clock, I'll call them back.
And then we'll make a decision either way. If they have no opinion, we'll decide as agreed.
And in the meantime, I will find out just how long we have tomorrow, and what it takes.
Who's, There wouldn't be a committee of conference reported, assigned until we decided to concur or not concur, right? So there's nobody, there's no committee of conference at this point. So at the very least, we,
Doing the what?
But I wonder if we may have to establish a committee of conference this evening to be ready for tomorrow, if we're not to find out.
But you can't vote. If we, and that's what I'm trying to find out from the clerk's office, is can we do that tonight?
Okay, we're off the floor.
So it's being,
Yeah,
so, well, I don't know whether we adjourn or not.
Right.
so at the very least, we should at least contact our colleagues in the Senate and say what the possible issue is and have them thinking about it while we're thinking about it, or while we're waiting for an AG opinion. And that way we'll guarantee it 5 seconds.
I'm unclear why you didn't ask the AG for opinion earlier. That's what the question on my face.
Didn't think about it.
If there was, I didn't realize you were concerned, you could have been working on this.
Well, I started to, all this language was, talking about lawsuits and potential unknowns, and I said, geez, we never heard from, never asked the AG, I better give him a call. So,
We're back.
just
on
like
track.
we never thought to ask you whether or not the board would on their own tell the applicant that their CPG may be conditioned by rules later on. And Senator Ash thought to ask that question.
But I do remember at one point asking someone from the PSB what they thought of this sound rules. And they didn't indicate a problem, so.
Well, they didn't indicate a problem on doing rulemaking. They weren't commenting on the legality of a retroactive date.
I thought that was all.
I don't
My
know.
question.
One thing I'd like to just add is that in terms of the legality of the retroactive date, legislatures can make things retroactive. The question is specifically the constitutionality.
Right.
Because otherwise, the legislature makes the laws.
Right.
So so just to be clear, it's a question of whether it's constitutional or not.
So Claire, did you find out whether we're adjourned or
Till
recessed?
7 p.m.
Just,
We're off till 7?
just recess.
So this is dinner hour.
Yes.
All right, we're adjourned.
So when?
So you're on the floor at 7,
Yeah, but this committee, when are we?
9 o'clock tomorrow morning.
So is this the only issue we maybe have? with
No,
the
we
Senate?
have one more. We have your municipal bill, which is now the collect-all bill from the Senate. They have loaded absolutely everything left in their pocketbook on 577.
Which one was
Is
that?
that the,
That was the.
That was the change of the voting for 10% of
Oh, yeah.
their,
It was a very little bill.
Right.
oh, yeah.
so it's now a Christmas tree.
Electric
Municipal
cooperatives.
utilities.
Okay?